Hello everyone, welcome back. In this video, I'm going to talk to you about the Baker Act and the RTR, the request to release, and who actually can sign the RTR. So I've talked about the two types of Baker Act in the past. There's involuntary and there's voluntary, right? Involuntary has a 72-hour clock ticking, and voluntary has no clock ticking, and it could potentially lead to an indefinite hold without due process, without a court order, without any of the things that you would associate with, well, I've just agreed to have myself locked up. And so a lot of the time I get folks calling me, or their family members are calling me, and they're saying, we're going to sign an RTR, or my loved one's going to sign an RTR. And I'm saying, you shouldn't do that. You should let me, as your lawyer, do it. So first of all, let me explain to you how and why I'm able to do that. The statute, Chapter 394, which is the Baker Act, and the specific section is 394.4625, is what authorizes not only your loved one to request, the RTR document, but for the attorney to actually revoke the consent. So why is it better if I do it? Well, if you do it, your loved one does it, in all likelihood, they're just going to ignore it. Or they're just going to say, well, if you sign this, here's what's going to happen. And then they start making up all this ridiculous stuff about how they're never going to get out of there. They're going to get a court order and all of this other stuff. Okay. And frankly, I think it's a fool's paradise for your loved one to actually request to be released after they sign a voluntary admission agreement. And the validity of that agreement, by the way, is a topic for another day. And I've waxed poetic about it in the past. But if I do it, now they understand what's really going on here, because when I do it, it's done in an official pleading with the court, and I'm already telling the court about the illegal action the facility has conducted, the fact that the informed consent probably, wasn't informed, right? All of these things. And so when I do it as your lawyer, it carries significantly more weight. And that's what gets the facility most of the time to say, you know what, who needs the aggravation? Aster's a pain in the butt. And we know that Aster and his team are going to fight, and they're going to continue to fight until we let this person go. So, you know what? Out of 100 people, Aster's only representing one. We'll let this one go, and the other 99, we'll keep them there for another day. So when it comes to the RTR, my personal philosophy is you should let the lawyer do it. Don't have your loved one do it, okay? Because they're just going to get bullied in there, and in all likelihood, it's just going to get ignored. That's my experience. So I wanted to share that with you about the RTR. Really important, let the lawyer do the legwork for you. Let the facility deal with me, because they'll take notice of, especially when they get served by my process server and they get notice that they have just been dragged into court, and now they have to explain to a judge what they've really been up to. If you guys do it or your loved one does it, in all likelihood, it's not going to change anything, and it just may pour gasoline on a fire. So that's my personal counsel to you with regards to the RTR. And once we revoke, the facility's got 24 hours. They either let your loved one go, which they do most of the time, or they're going to file a petition for placement. Fine, let them file it. Now we're going to get a hearing, and now the judge is going to hear about all the shenanigans they've gotten up to. And so that's the RTR. Thanks for tuning in. See you in the next video. Bye-bye.